Thank you, Malek, from Malek and Malek. Today, I'm going to talk about a topical subject to me, anyways. For the simple reason, a lot of these videos are triggered by some kind of either some client's issue that I'm dealing with, or a case that I have ongoing, or somebody that's called and asked for advice or help with their workers' comp claim. So this one, um, I kind of have a case that's hinging upon some of these things that I'm working on right now. And then I actually got a call from somebody, which is the fact pattern fit with what I was going to talk about. So what I'm going to talk about today are injuries that occur to home health aides. And the reason why I'm talking about this specifically is because a lot of times when we get uh, folks who are home health aides that get injuries, it implicates this area of law called the going and coming rule. So, and what that means is, so stepping back, the going and coming rule essentially is implicated whenever you get an injury that's not at the location of work. So if you're in an office, you get hurt in the parking lot, or if you're you're working at like some kind of logistics warehouse. Again, you're not in the actual building, and you're stepping outside of the building, or you're in your car, or you're driving in your car and you get in like an accident in your car. So um, and it's kind of relevant to home health aides, because home health aides, what they do is they're home health aides, so they're driving from house to house to house to house, and they're providing the aid to their patients. So their patients don't come to like a nursing facility, or they don't come to like a medical office. The home health aides goes to them. And so what happens a lot, you'll see cases, or folks getting into car accidents. They're leaving either from the one patient to the next patient, and they get in a car accident. Or there's also situations where they're walking up to the patient's house and they slip on a driveway. Maybe it's icy, maybe it's wet, maybe they're on a porch and it's not stable or something. So they're either going into the house or they're leaving the house, and then some kind of injury occurs. Um, and this and the reason why these cases are kind of, these are what you call hard cases in workers' comp, because the injury might be obvious. The medical part of the claim is not the challenge. It's this going and coming rule, and which may or may not allow that person to file a claim in the workers' comp system. It may disqualify them from filing a claim. So in a nutshell, basically what the going and coming rule says is, and the base rule is, if you're driving to like your office, or you work at Myers or Kroger's, and you're driving from your home to Kroger's, and then you get in a car accident between home and Kroger's, or going from Kroger's to home, and you get in a car accident. Basically, the Ohio courts have come up with this idea, and I mean, it kind of makes a little bit. I mean, it makes sense to me, that the employer isn't. They shouldn't be responsible for every uh, like something that everybody faces. So everybody has to drive on the highway and the roads and stuff, and the employer has absolutely no control over what accidents may or may not happen. On the highway, with drunk driver, there's a pothole. Um, in the car, you lose control in the pothole, or you get hit by a drunk driver, or you get hit by somebody else. So the idea is the employer has no control. Everybody goes to and from work. So the law is, we're not going to cover injuries or claims that happen driving to and from work. So there's exceptions to this, and that's where you have to dig in with these, particularly with these home health aid kind of situations. You have to look at the facts of the thing and really dig in and see, okay, well, this kind of makes it more towards it should be allowed, or this, or the employer is going to say, well, this factor makes it so the claim shouldn't be allowed. So, and it's my feeling, looking at a lot of these cases, is that it's kind of unfairly weighted towards not allowing these claims, particularly with these home health aid situations. Um, but So basically, the rule is if you get and it's if you're it's not just if you're driving a car, but if you're um, you're again, you're not completely in the office. So you're walking from the parking lot and you slip on ice in the parking lot. Is that, does the going coming rule implicate that, or does the going coming rule apply? And then there's some exception that may actually apply that makes it within the rubric of the workers' comp scheme. So that's kind of what happens. So, um, but like I said, I think the law is kind of um, weighted against home health aides in terms of these situations. So, and here's the fiction. So the idea is that going and coming rule basically applies to everybody who works at what they call a fixed. They're a fixed situs employer, so they're a fixed site employer. Um, so if you work like I work in an office, I'm a fixed situs employer. I always go to the same office every day. Now, the court, they have this case called Cubby versus Ruckman involving these riggers, oil riggers, and they were driving all over Ohio from one particular oil rig site to another, or gas site. And they would go to, it would last for, a week or a couple days or whatever. And then they would go to another oil site. And in the midst of one of these traveling from, I think either their home to the rigging site or from one rigging site to another rigging site, they got in a car accident, or I think they went off the road or something like that. So, um, they filed a claim and eventually went through the appeals court, and then it ultimately went through the Supreme Court. And the Supreme Court basically, this fixed situs thing came up, and I think they've kind of perverted the idea of what it means to be fixed situs. But essentially, the way the law works in Ohio right now is um, you can be a fixed situs employer if your place of employment, like the place where you're going to work, if that changes, you know, monthly, weekly, or even daily. So you could go from one site to another site to another site, and then wherever you do they say the substantial employment duties. That is, if you do your substantial employment duties at whatever that place is, then that is your fixed site of employment. And so the way that this works for home health aides is, if you have like three clients, client A, you drive to client A, well, that's your fixed situs. Client B, that's your fixed situs. Client C, that's your fixed situs. So therefore, the going and coming rule, going from client A to client B, the going and coming rule is in play. Again, I think that's a perversion of that idea, to imply that each of those is their fixed situs. But that's how the law works in Ohio. So that's the game, and that's the way that we're things are changed, or operate. So if you want to change that, maybe if vote in Ohio Supreme Court justices that you think are more likely to find that that is not the way that the law should work. So, and the thing is, some of these Supreme Court justices, you just have to see who's backing them, and what are their affiliations. If they're conservative, they're more for businesses and stuff, so they would tend to go for laws like that. If they're more liberal and more behind the workers' position, then they're more inclined to see the workers' side of things. So if you want it to change to be more towards the business side, then vote for the business oriented Ohio Supreme Court justices. And likewise, if you want the other way and you want somebody to go for more of the worker side of things, then vote for those Supreme Court justices that would likely tend that way. And likewise, if you want the law to change, same thing. So, but that's how it is. That's the law in Ohio right now. So, that's the basic rule. And then, so there's exceptions. So in the going and coming rule, they found that these riggers were fixed situs employees, but there was an exception, the special hazard exception. And within that special hazard exception, it was the actual special hazard that exists in that case was that the fact that they drove interstate and interstate in a degree that is more than the general public would drive and so because of that, and they faced a higher risk because of that. So therefore, that exception kicked in, and therefore it went from being non compensable claim to falling within the rubric of the Ohio workers' comp system. Um, and this stuff comes up, like I said, all the time in home health aid cases. And one of the a call I got, a potential call I got, was the person had they had done whatever they're doing for their patient. They were done. They would usually go out one way, and then instead of going out that one way, they went out the back entrance. I think the front entrance there was construction or something. Um, and so they went out the back way. As they're walking down from the porch from the back way. They somehow they tripped, or there was something in the step that caused them to fall, and they suffered some kind of fracture and some other kind of leg injuries. Um, and so and I think, if I can remember correctly, the facts in that situation were they had with all these home health aid situations, particularly if it's Medicaid, if it's a Medicaid patient, there's like very strict guidelines of how they track their work. So they have to like log in and log out. So I think they had logged out of that patient. So an employer would argue, well, that you were done with your work, and therefore the going and coming rule applied. And while you're stepping out and you tripped on those steps, it shouldn't be a compensable claim. You would think, well, I was working, that home health aide would say, well, I was working and I was leaving the patients and I was right near the patient's house. Therefore, it should be a compensable claim. And you would, and it, I would think I would think it should be a compensable claim. But there's actually appeals cases that very similar factual situations had arisen, and that claim wasn't allowed. And there's a case that I would mention, and get on my, okay, let's see, where is this case? Okay, so, and this is kind of a similar thing. I think the difference is, I think that this person who called, I believe they may not have been done for the day. So I think they may have been between clients um, visits. But this person, so this is this Mitchell versus Cambridge Home Health Care. In this case, the person their patient was in an apartment complex, and they had done whatever, provided whatever aid they were going to this patient in his or her apartment. They were done for the day, so this was their last patient of the day, and they were leaving the apartment. So apparently they left the apartment itself. Maybe it had some elevator or whatever, but they're walking out of the apartment building, and they tripped on a mat and exiting the apartment building, suffered some kind of injury, um, and the court didn't allow that claim. Okay, so um, basically they and when you do the analysis in these going and coming type cases, is there's two things that come up, and this is true of any workers' comp case, but it comes up more. It actually becomes an like an elaborated thing in these cases where the injury doesn't happen in the office or the warehouse or the store where the person is working. But so the injury has to be sustained in the course of employment. There's in the course of employment and arising out of employment. So in the course of employment, it basically is saying that um, the employee was engaged in a duty required by the employer, and it considers the time, place, and circumstances of the injury. So in this analysis, I don't know if it failed on initially in the course of employment, but it ultimately has to get past that, and then it has to rise out of the employment as well, where there's a causal connection between the injury and the employment. And so this is where a lot of the analysis occurs. And so they apply this totality of circumstances test from this Lord v. Daugherty, and it's basically there's three things they consider: the proximity of the scene of the accident to the place of employment. So looking at our example with the person who tripped on the porch, the proximity of the scene to the scene of the accident to the place of employment. Well, the place of employment was this home health aide or this patient. So I would say that one, they click off on that one. That's a positive for the injured worker. The degree of control the employer had over the scene of the accident. So in this case, this would be a negative because the employer had absolutely zero control over this patient's house. The benefit the employer received from the injured worker's presence at the scene of the accident. I would argue that in this case, the employer received a huge benefit because it's their business. Home health aides are in the business of that's how they make their money, by going to patients' houses and providing aid. So I would say 2 of those 3 go for the injured worker, 1 goes against. Now, in this case, so that's the potential call situation. But in this one, this Mitchell versus Cambridge home health care case, they said the totality of the circumstances situation didn't meet. First of all, so this is taken from the actual decision. Every employer has benefited from their employee coming to work rather than seeking an absence. Okay, so I guess they're saying 3 is kind of a wash. So they're saying that benefits the employer. They say every employer benefits from their employees going to their workplace. Therefore, this is not. We're going to apply a neutral value to that number 3. And then they say the proximity is kind of weird in this one because I don't really understand how they would think I think they kind of made some kind of argument that this is a closer proximity in this case to the workplace than so in this case they were pretty close to the place of employment. So that would be a plus factor for that claimant. But they said there was the degree of control. There was no degree of control over the accident site. So they looked at it, and it's not like you get 2 out of 3 and you win, or you get 2 out of 3 and you lose. They could place more value on one factor than the other. But in this case, they said this person's claim wasn't allowed, which I think is kind of crazy because they're providing aid, they're walking out and they trip and on the mat, like leaving from the apartment. But I guess because that was their last patient for the day, they were done working, that they say this going and coming rule comes into play, and therefore not allowed claim. So that's that case. So and there's a lot of these. If you look at like these home health aid cases, it seems like the predominant thing is they're not going to cover it. And then there's the issue of when there's like the other thing that comes into play where it's when they're going from A to B, where did they get injured? And then the other issue is what were they doing? So they have a couple of cases where person that got stopped. This is Gilham versus Cambridge Home Health Care, and they had stopped and they had gotten a sandwich from their second patient. So they were done with their first patient. They stopped. They got a sandwich between the first patient and the second patient. They were leaving to go to the second patient, and then they got in an accident. So they were 3 miles from the second patient. So in the court in that case, they applied this proximity to the scene of the accident, the degree of control the employer had over the scene of the accident, and the benefit to the employer. And they found that the employer exercised no control over the scene of the accident. So, and that would generally be the case of any time when you're on the road. The employer's not going to have any control over that road. Okay, that's always going to be going against you. And then they said, the proximity was about 3 miles, so it wasn't that close in that case. And then the fact that even though they were going on the way to the second client, that did not confer any benefit to the employer. So they disallowed that claim. So, and that seems pretty, you're like, man, that kind of sucks. So if I get in a car accident, from point patient A to point patient B, I'm not going to have a allowed claim. I don't know. It could be that they're like, well, this person, I don't know. you should be able to get lunch, but maybe they're thinking there's things that aren't in the actual um, decision that may have come to play that tended to make the judges disallow it. But maybe they're like, well, she wasn't really going to the person's house; she was going from lunch. So but there's a similar. So I'm researching for this other case I have, and so I'm looking at these. Again, I'm looking at these home health aid cases, and a lot of what happens with with these going and coming cases is if they may be allowed or they may be disallowed at the administrative level at the industrial commission, um, and then the next step is you file in a court, and as part of a court case, there's things that could happen that prevent it from actually being heard by a jury. So, and one of the big things would be somebody files a motion in summary judgment on an issue, and then the judge either rules on that issue, granting that motion, or they deny it. And so, one of the things that they'll with these going coming cases, they'll submit a motion summary judgment stating that the going and coming rule applies because of this and that evidence that has been garnered through the discovery process. And so, and what the summary judgment basically means is there's no, like a reasonable trier of fact could come to no other conclusion but the conclusion that the person is putting the summary judgment. So, for instance, if they're submitting a motion in summary judgment about the color red, okay, so that's the issue. The case is about whether this ball is red or not red. So the plaintiff or the claimant's attorney or is trying to argue, well, this ball is not red, and then the defense is trying to argue that the ball is red, and they get evidence from folks saying, well, I look at the ball and under this light, to me it looks red, and then they get like scientific, they get an expert, and the expert says, well, I've taken scientific measurements of the wavelength of the lights bouncing off the ball, and they've measured red, and therefore this ball is red. So the defense will submit their motion saying, basically, there's no fact that could go to a jury that the jury could come to a different conclusion. So basically, there's no reason to go to a jury trial because a reasonable jury member would find that the ball is red. So in that case, because they have scientific evidence and whatever, the judge might say, okay, well, the ball is red, and therefore I'm going to grant the motion summary judgment, and the case is done. So in these cases, what the claimant is arguing that the going and coming rule doesn't apply. The defense is arguing that the going and coming rule does apply, and then before it even gets to a jury, so there might be an issue at trial of this going and coming issue, and then the other issue may be a medical issue, the injuries, trying to prove the injuries that the person suffered. So a lot of times, again, they'll submit these motion summary judgments, and that's how you get a lot of these home health care cases. Like they'll submit a motion to stop the case from even going to trial, and sometimes they grant them, and then they go to appeals courts, and then somehow some of these cases end up going to the Supreme Court. So I was like, in my research, I was like, man, these home health, Ohio is really down on home health aides. It's really kind of lame, because you think you're providing a huge service and benefit for the community of Ohio. In this case, it's Franklin versus B&H Services. And so this is one of those situations where the trial court had granted summary judgment that the home health aides wasn't a compensable claim. And what happened is the home health aide was driving from like patient A to patient B. Okay, so they're patient A to patient B. And so the trial court granted the summary judgment, so the case is done. The plaintiff's attorney representing the aide filed it to the appeals court, and then the appeals court took it up, and they basically, what all they're deciding is whether this motion was correct or not, whether the case was properly, was if it was granting of that summary judgment motion was correct. And so in that case, they found that, and the term of art is there's no genuine issue of material fact. So if there's no genuine issue of material fact that the ball is not red, then they're going to grant the summary judgment that the ball is red. Okay, there's no genuine issue of material fact that the ball is red, so we're going to grant that summary judgment um, that the ball is red, and the case is done. So in this case, they're saying there's no general issue material fact that the going and coming rule applied, therefore the case is done, summary judgment granted. So they appealed, and then the appeals court said actually there was a genuine issue of material fact, whether the going and coming rule applied, and whether they're in fact a fixed situs employee. So they're even going back further, and they're saying, well, because if you're not a fixed situs employee, then the going and coming rule doesn't apply. So, and they said the aide had no office, or the travel was an essential part of that aide's job. That person was assigned, the aide was assigned to see more than one client on the date of injury. And then even though they weren't paid for travel time, travel was subject to reimbursement. So on that issue of the fixed situs issue, they said there was a genuine issue material fact, but they weren't finished. And so what happens when the appeals court finds there's a general issue of material fact, that a fact finder, that basically they're saying a fact finder, i.e. the jury, could come to a different conclusion. And if there's a possibility that the jury could come to a different conclusion on those facts, then granting of summary judgment, it would be improper. So the genuine issue of material facts was, so in regards to that going and coming situation, they said the injury occurred minutes after that person left the client's home while en route to the second client. And so they're saying, and it was a duty required by the employer. So they're saying in terms of, so you look at those three factors: proximity to the scene of the employer's business, or where the business is going to be conducted. They consider that, the degree of control the employer had over that, and then the benefit to the employer. So in that case, they found there was a genuine issue of material fact. So bottom line, these going and coming cases can be very factually intensive. If you're a home health aide and you have you're not injured in the patient's house, call an attorney, get advice on what to do next. Don't do it by yourself. Okay, so that's my advice to you today. If you have a question, concern, anything, call our office, leave a comment below. We'll talk to you, and we'll give you some advice. If you want to hire us, we could talk about that as well. So thanks for watching this video, and good day.